Well, you may have seen that Vardy and Rooney case is back in the news again. You know, the so-called Wagatha Christie case, or as I like to call it, the Scousetrap. This time it's all about costs. So I thought it might be interesting just to sort of discuss what all these issues are, but also just knowing about cost generally, because this is applicable to anybody who unfortunate enough to get embroiled in litigation. So, you know, sneak a bit of useful education in there, hopefully. Um, to go back to how this all occurred, basically Rooney, I'm going to use surnames because I can't remember their first names. I've seen in my Night Lawyer video about never knew anybody. Um, she was concerned that somebody was leaking her private information from her circle of friends and her private Instagram account. So she went all Sherlock Holmes and she started putting very clickbaity stories there that she knew journalists would be interested in. And also, she started narrowing down the pool of people who had access to it till eventually there was just one person, Rebecca Vardy. Oh, I remembered. Um, and she published, she tweeted out explaining what she'd done and said, and it's Rebecca Vardy's accounts. Rebecca Vardy took this rather badly and she said, no, it wasn't. That's not me. So she, in possibly the most ill-advised piece of litigation since Acme Delivery Company tried to defend against Wile E. Coyote, she brought a defamation claim. And you remember it was all full of all sorts of twists and turns. There were, problems with disclosure, not going to get WhatsApp messages. Oh, laptops suddenly can't remember the password, and phones falling into the sea off ferries. And I bet Boris Johnson wished he'd dropped his phone off a ferry. But ultimately, there was the trial, and at the end of the trial, Rooney won. She proved the truth of the allegation, so she was the winner. So the consequences of that are, in England and Wales, we have a rule which is loser pays winner's costs, to be differentiated with the so-called American rule, which they have in, guess where? America, where you pay your own costs. I mean, over here, you only do that with what we call small claims track trials, under £10,000. Then you pick up your own costs. And there are sort of fixed costs in other cases. But generally speaking, if it's a complex case, it's, loser pays. So the judge made an order and said, okay, you are to pay, the claimant is to pay the defendant's costs. However, did throw Bardi a bit of a bone here, because although Rooney primarily pleaded, look, these allegations are true, she also ran public interest as a defence, which you might remember from the other videos. That is a defence even if something's not necessarily true. What's interesting is she succeeded on the truth, but the judge said, actually, I will look at the public interest thing because we spent a bit of time on it. I actually find that this wouldn't have been in the public interest to publish at this stage, because once you found out, you could have actually just gone back to her and said, hey, what do you have to say about this? Then you could have published, but it wasn't right not to get her, explanation. So she lost on that. So the judge said, okay, we spent a bit of time on that. You've got to pay 90% of the costs. We also said you've got to pay them on an indemnity basis. So what does that mean? Well, let's just start with cost generally. The starting principle is lawyers can charge their clients whatever they want. They can charge any hourly rate. They can just charge huge fixed fees. However, the other party in the litigation doesn't have to, just because you've agreed something with your lawyers, because that's purely contractual, they're not obligated to, pay just what you agreed. So the starting position there is we have a set of guidelines for what people can charge for their hourly rates. And it's all divided into different grades of fee earners. There's 4 grades of fee earner. I'm actually I'm in the top grade, but that's not, not skill thing. It's just like how long I've been doing this. I mean, you actually move up just by, living longer. But you've got those 4 grades, and also they're differentiated around the country. So weirdly, because if I do something in Cornwall, I'm in the lowest recoverable band. But if I do something in London, I'm in the highest. So if clients say, we should, we should let's issue this in Exeter. No, let's issue it in the Strand. Actually, no, because prefer not to travel. Save the diesel. But that's one of the factors they look at. And when you sort of win a case, you put in your cost schedule, which is what costs you've actually incurred. You've got to get that in no later than 24 hours before the judge is going to determine that. And if you don't, you can lose out. I had this once where I had a terrible claim where we were trying to enforce a loan was only repayable upon the death of certain people. And they turned up at court. And the judge just sort of looked and went, well, they seem alive to me. I was like, so tempted to say, are you a doctor? But, threw in the towel, the judge said, yeah, wise move. But when, said, well, what do we do about costs? Anything to say? And the guy, the other side was a mate of mine. And outside court, he hadn't actually put the schedules in the hour before, the day before. He just gave me outside court. And I had a look at it, they're only like small, they're only like a couple of pages. They're easy to grasp. And I said, well, the only thing I really say is I didn't get the schedule, in the 24 hours. And the judge just went, yeah, neither did I. Bang, you don't get them. Like, what? So that was really bad. I said, be more careful next time. But yeah, you put your schedule in. And normally the judge he awards you a cost on what we call a standard basis, on the standard basis. And you can only recover costs that are reasonably and necessarily incurred and that are proportional to the overall cost of the litigation. And it's for the receiving party, that's the party getting the costs, to prove that the costs were reasonable and necessarily incurred. Okay, so the starting position is you've got to justify all your costs, and the paying party can just object to them. And also overall, they've got to be proportional. So if we sue, if you sue for £100,000 and you've racked up $3 million in costs, we might say no, that's just not right. Okay, although this is a problem because costs, are an issue. I mean, I think on average now, over all cases, for every £100 in damages recovered, there's £197 in legal costs. So this is why so many cases settle. It's never about the merits of the case. You just got to take a cost-benefit analysis about, take a commercial view. Is it going to be worth it with all the cost risk? Because you're not going to recover all your costs. Because you'll be lucky to recover 70% of your costs on a standard basis. Because the judge will say, well, yeah, I understand, why you did that, and that's fine, but we could have done without it. It wasn't necessary, or you went, you spent too much on an expert and things that wasn't reasonable. All these sorts of things. So you always get knocked down quite a lot. I mean, on if the hearing lasts less than 1 day, the judge will do what we call a summary assessment, where you put your cost schedule in, and they'll do a very rough and ready calculation. So your hourly rates look about all right, but you could have got somebody a bit more junior to do that bit of work, so I'll knock a bit off there. You didn't need quite that long to draft the statements, I'll knock a bit down. But they just decide there and then. But in a more complex case, they go off for assessment, okay, and that's where you have these arguments. But what a judge can do is a judge can say, well, because of the way you conducted this case, and it can be things like not complying with orders, not accepting reasonable offers of settlement, but also, hiding disclosure, like dropping things off ferries. So because of your conduct in this case, you're going to pay on what we call an indemnity basis. And that is meant to be a punishment. And with an indemnity basis, the costs still have to be reasonably and necessarily incurred. But it's for the paying party to argue they're not. So the starting position is all these costs are reasonable. It's for you to argue why they shouldn't be and to knock everything down. And also proportionality isn't a factor. So it's like, well, it doesn't matter if they've racked up $5 million in legal costs. We don't take that into account. You've still got to go through line by line and try and knock everything out. And like I said, these go for what are called a detailed assessment, where you get a special cost judge, and you do go line by line through every item. But people try to avoid that because there's a cost of the assessment. And the usual rule is the paying party pays the cost of the assessment unless they are able to knock the cost down by a significant amount. You say like more than 20%, in which case the receiving party pays the cost of the assessment. So you've got costs of costs, and cost of costs. It all gets very sort of meta in inception. So people try and avoid that. They'll say, well, the judge will make an order saying cost to be assessed if not agreed. However, you're obviously going to get some costs, even with most draconian cost judge. So you get what's called an interim payment on account. And what happens there is the claimant always says, oh, we're about to get all our costs, give us 70%. And the paying party always says, oh, no, their costs are ridiculous. We'll get them knocked down. We'll offer, how about 50%? And the judge will usually come and say something like 60, 70%. You pay 60, 70% of the cost now, and the balance to be assessed if not agreed. In this particular case, the judge went quite high. He said, I'm going to make quite a high, because I've ordered on an indemnity basis, I'm going to go, quite high. So Rebecca Vide had to pay £800,000 on in costs straight away. Well, within 14 days. And the rest, they're now trying to agree them. And there's all these sort of interesting rows about sort of, very, £300 hotels and expensive breakfasts. So they'll have to. But the thing is, it'll be for Vardy to say that wasn't reasonable or necessary. And Rooney's Lot will no doubt be saying, no, that was the most convenient and reasonable and cheapest place to meet, to have this discussion before the trial. And, it saved time having breakfast there and then rather than, having a run down to, McDonald's. So, yeah, that's going to be a really interesting one. One thing, though, is we also have what we call cost budgets. All high profile, high value litigation has it now. It used to be just in defamation, because we started it because of course we're the silly money division. And a cost budget it's like a spreadsheet, and each side prepares at a very early stage in proceedings. They predict what they're going to spend, and it's divided into things like witness statements, gathering evidence, time spent with the client, time spent discussing things with the other side, time spent instructing experts, the costs of the various hearings before the case, the cost of the final case. All goes in. Who's going to be doing what grade of fee earner, how many hours they're going to spend on everything. You spend ages typing that out, and it pops out a figure. Boom. And you go in front of a special type of High Court judge called a master, who deals all the preliminaries, and you'll try to get your cost budget agreed. Now, the other side, each side can make objections to each other's cost budgets. Oh, you don't need to spend that long on that, or that great fee earner's far too senior for this level of case. Although quite often people don't, because at this stage you want your cost budget to be accepted, so you don't want to object too much because so, this is ridiculous. You don't want to spend all that money. Well, that's what you're doing. So quite often the master will just sign off on each party's cost budget. So it's obviously, if you can come within your cost budget, then obviously that really helps you with costs, because it's like, well, look, this is what we said it would cost us, and this is what it cost us. However, the courts do recognise that, when you put in a cost budget in at that stage, it's a bit crystal ball. It's not like, it's a lot easier to assess what the costs were once you've actually incurred them. So they accept that a costs budget and a cost schedule are created in very different circumstances and are very, very different animals. Because in this particular case, apparently they've gone way over the cost budget as well. But like I say, that might not be a factor. I think the figure I've seen is that it's something like 1.2 mil or 1.5 mil that Vardy is still on the hook for. So if they can't agree that, then it will all go off for detailed assessment, which of course will incur yet more costs, and this saga will continue. But I just thought you might enjoy that update in the interim.